I ever leave this world alive, I'll come back down and sit beside your feet tonight. Wherever I am, you'll always be more than just a memory. Well, if I ever leave this world alive.
Hey folks, Professor Finn here, and welcome back to the channel. I have been gone for a hot minute. I've been super busy, got some really exciting things coming up that maybe we'll talk about in the future. But I got a DM this week on Facebook asking me about a funeral-related question. I said, hey, you know what? If I get a chance to get around to doing this, and here I am on a Friday night, busy day, and this initial dialogue occurred like Tuesday of this week, I'm going to record a video about it. I'm going to throw it up. So this person works in allied health. She's a former college acquaintance of mine and was asking about, rights of parties and things like that. So the first thing is the necessary disclosures that I am not an attorney. I am not licensed to practice law in the state of Florida or any other state, and I am not qualified to render legal opinions. If you are looking for something like that, you need to go to a licensed attorney in your jurisdictions, preferably one that practices in the areas that we are looking at, which is generally probate, wills, and estates, and seek their help and guidance. Now, a good first step for anyone is to call the Division of Funeral, Cemetery, and Consumer Services, and we are on their website. We're going to see why we're on the website here shortly, because it is a wealth of information. So what we're going to do is we're going to look at some statutes. We're going to talk a little bit about how things interact, and I'm going to feed you some information about my time in full-time practice as a funeral director of how these things might pan out. So the situation was a person passes away. A legally authorized person or a next of kin, and I will use those terms very specific because they mean two different things in the legal world, and the proper way that I'm going to refer to the individual in charge of things is the legally authorized person, which may not be the next of kin. And they went to a funeral home, and the funeral home said, well, no, we're not going to let you ID. We don't have to, or something similar to that effect. And the question then became, well, if I want to ID and I'm the person in charge, can I do that, and can I enforce my will? So let's talk about the first aspect, which is who is in charge. Now, the beautiful thing about the division is they have a wonderful thing in their licensing section that you scroll down and you will find the Florida Laws and Rules Exam Study Materials. Now, they got this really cool outline that I wish they had when I was in mortuary school, so you can bet your bottom dollar that I'm going to be sharing that with my students. But they then list anything that is testable for the Laws and Rules examination. To put this into perspective, when a person finishes mortuary school, they will take a competency exam essentially for funeral service practice, which is the national board exam as administered by the International Conference of Funeral Service Examining Boards, so RNBE. This basically says that they possess the minimum criteria at that moment they take that assessment to engage in the practice of funeral directing. And a lot of the states in the United States use this exam to determine minimum competency. It's a board exam. The next thing is at your time of full licensure, you will take an exam on the laws of the jurisdiction in which you wish to practice. So if you wish to practice in Florida, you will apply to be a Florida licensee, and you will take a Florida Laws and Rules exam. And this is the same in just about every state that has regulation for funeral directors. You apply for the license in that state, and part of that process is you will take a Laws and Rules exam so that the state knows that you are well-versed in their specific practices. And the reason why we're here is because if it has something to do with disposition of dead bodies in the state of Florida, it's going to be on this exam. And if it's going to be on the exam, it's likely going to be found in one of the areas they want you studying. So we have a couple of different statutes: 382, 406, 497, 733, 765, 872, and 3 rules. Everything past this is federal law, which Don't take me wrong. It's important, whether it's U.S. code or code of federal regulation. It's important, but it is not Florida specific, which means the federal government is not going to tell you how you're going to identify bodies in the state of Florida. The state of Florida is going to tell you how you're going to identify bodies if the state of Florida does. So you can immediately narrow down where it is that you need to look at things by just going to the Florida statutes. Now, I've taken the liberty, and you can't see my toolbar, right above the recording, but I've taken the liberty of going through and looking at a couple of things already. So I'm not going to open each and every one of these up because there's just too much there. So we're just going to kind of jump through the different ones that I found. And the first thing that we're going to talk about is the hierarchy. Okay, the hierarchy of who it is and who is a legally authorized person. And we find this actually in Florida Statute 497, and Chapter 497 is the main regulatory statute for funeral service. Just about anything you want to know about funeral service is in 497, and then when you add in those 3 other administrative codes, you get a pretty good idea of everything that's going on. So we are in 497, subchapter 5, which is the definitions section. In any time the state or the law wants to define something, that's an important thing that you need to look at, is the definition, the legal definition of what something is in that state. So the state of Florida actually gives us a legal definition for legally authorized person. Notice that we do not have a legally, if we go down here to next of kin, we do not have a next of kin definition. So the proper term for a person in charge is the legally authorized person. Means in the priority listed. The decedent, when written inter vivos, authorizations and directions are provided by the decedent. So they're saying that the person ultimately in charge, the top of the list, is the individual when they have written something in life, such as a directive to get things done. So a pre-need funeral, for instance, signed, sealed, delivered, and paid, would probably be enforced by a court of competent jurisdiction with a judge that has the average competency of a carrot, because that is the first thing on the statute. But you're probably going to have to go to court to maybe prove that and enforce that, because things get a little bit cranky. Item B, the person designated by the decedent is authorized to direct disposition pursuant to a specific rule as listed on the decedent's United States Department of Defense Record of Emergency Data, DD Form 93, its successor form, if died while in military service. So what we're looking at specifically here is if the person is active duty military and they pass away, the second person in charge is the person that they have directed to be in charge. Plain and simple. That's what that says. But the criteria is they had to be basically in the military service or the reserves on duty so that this comes into play. And you can see that this would supersede even spouses, parents, siblings, etc. So this is why the hierarchy is important, is who is the legally authorized person, and if you're going to take it to court, what is the likelihood that you are going to prevail? Because judges must defer to the statute. Judges are supposed to defer to the legislated law of the jurisdiction in which they are presiding. So a judge can't just make up an exception to this rule because a judge feels like doing it. That could get the judge in hot water. The surviving spouse, unless the spouse has been arrested for committing against the deceased an act of domestic violence that resulted or contributed to the death of the deceased. So now we are back looking at something from the common law way back in the day, as who's in charge, and it goes through the hierarchy of you start at the spouse and then you go to adult children and then parents and siblings and whatnot. So from here on in, we are looking at generally the common law of England that is influenced just about every state in the United States. So this is the basis for mortuary school. We start with a spouse as the next of kin or legally authorized person. State of Florida does make an exception that if the person caused harm to the decedent, if that harm contributed to their death or actually killed them, then they are relieved of that privilege. The next person then is an adult son or daughter who is 18 years of age or older, parent, siblings 18 years or older, grandchildren 18 years or older, a grandparent, any other person in any degree of kinship, second cousins on out, nieces, nephews, etc. And now something very important. If no family member exists or is available, the guardian of the deceased at the time of death, the personal representative, the attorney of fact, the healthcare surrogate, a public health officer, medical examiner, commissioner, or administrator acting under Chapter 406, which is one of the other statutes. And it just keeps going and going and going. Until it finally gets to, or a friend or other person not listed in the subsection who is willing to assume the responsibility of the legally authorized person. When there is a person in any priority class listed in this subsection, the funeral establishment shall rely upon the authorization of any one legally authorized person of that class if the person represents that he or she is not aware of any objection of a higher priority. What this is saying is if you have a grandparent who is running things and the deceased has a brother who is completely disinterested and wants nothing to do with anything, the grandparent can attest that yeah, there are these other people that are in power, but they are disinterested and they're letting me be in charge. And the funeral home can basically take that at face value. There is no real world application that a funeral home should do that because they're going to want to get that in writing. You can't take someone's word for it because they could be just flat out lying to you. So common sense and a fear of a malpractice suit likely is going to compel most competent directors to reach out and say whatever. Where this generally comes into play is when you are dealing with either this or that, when you are dealing with sons and daughters or parents, and there are multiple parties in the same class. So, for instance, if there is no surviving spouse, they do not have an active form with the military, but they have 4 sons, 4 children, 4 adult children over the age of 18 that are legally competent. And one child is in charge of things and says, yeah, my brothers and sisters don't want to be involved. They are completely disassociated from my father, blah, blah, blah. You can rely on that statement even among the same class. Again, you would probably be insane for doing that because people lie all the time. But essentially what the state is saying is when a funeral director is acting in good faith on a representation, that they are shielded from frivolous lawsuits. They may have to go into court and defend against it, but they are generally shielded against liability. So this does come into play more often than you would think. That's an unfortunate reality. But there is a reason why funeral homes get multiple signatures in cremation to make sure that everyone is on the same page. And if it starts turning into a fight, you go to your corners, you get your attorneys, you hash it out in court, and away we go. So the first thing is when a person says, are they in charge? They are the legally authorized person, or they are the next of kin. The next of kin might not be the legally authorized person. Case in example would be a spouse that, ends up killing the decedent, and they would be in charge and they try to run things. Turns out that they are under suspicion for their murder and they are convicted or they are put in jail prior to, they are charged with the death or domestic violence. That person would forfeit their right. And while they are the next of kin, they're not the legally authorized person. Notice that this can be completely separate from something like probate law. A person may forfeit in some states, and the state of Florida is pretty consistent with this. If you contribute to someone's death, you forfeit your right to your portion of their estate. So if you were a spouse, you're going to get $50,000. That was what you were going to get, but you killed the person. You don't get the $50,000 anymore. That's poof. And then you let the probate judge and your attorneys hash out where it's going to go from there. But at the end of the day, determining who's a legally authorized person is a subject for the courts. This gives you an idea of where you stand when you want to argue it. And again, a judge can take into considerations, a judge can do this in equity and say, well, maybe a person that's a primary caregiver that is a parent can go against an individual that is not necessarily taking care of them, has been absent, now just wants to wreck things up like a son or daughter. But in general, that is like single-digit percents. That's just not something judges like to do because judges don't like to create exceptions to legislation without pretty damn good reasons, or if it's a multi-billion-dollar high-profile case like, oil tycoons marrying 18-year-olds. They're 90. Their new wife is 18, and they are set to inherit a $500 million estate. Well, state of Texas went through that. The biological son actually died during a state it took that long, and they actually limited the amount that the spouse could get at that point because of the fact that they were basically a trophy bride, which everyone understood. It's just, how much are they entitled to get under the law? A judge actually went pretty far to say, what we're going to do is we're going to not give you $500 million because, just because you married the person at the last minute. So step one, just because they say they are the legally authorized person doesn't mean they are. And this is the way that a funeral home would kind of determine who is a legally authorized person. But then they're going to perform some due diligence. Okay, so how many sons and daughters? Oh, there's like 6 of us. Okay, so where are they? Do you have contact? Oh, I have no contact with any of them. That's kind of a red flag. So you are disassociated from the rest of your family, and the entire rest of your family is disassociated to you. I can't proceed until really we kind of flesh things out a little bit. I'm not saying that some funeral homes don't just go ahead and stick with that. Hey, I got one person to okay, and that's okay with me, and they made the representation. I'm saying that when you get dragged into court, you're likely going to start having this really uncomfortable decision or a discussion as to what a licensed funeral director would do in like or similar circumstances of, comparable cognitive ability when put into this type of situation. Not going to say what is the textbook ideal example, what do people actually do? And it wouldn't surprise me if we find that more often than not, funeral directors don't rely on a single person just for the giggles of it. So digging through, I managed to find a legal opinion from the Attorney General's office from 1993. And I thought this may, give us a little bit of information, but anytime you have an advisory legal opinion, again, this is the way the Attorney General would prosecute or would argue something in court. This is not a guaranteed outcome because it is not a court judgment and it is not legislative law. And what they were talking about is lengths of time in which a body must be claimed before a county can direct burial. So this is way back in the day. We see that the Florida statutes have been updated to include a lot of these things. And when I thought maybe there might be something in here hidden about identification. No, folks, there wasn't. Okay, there's nothing hidden about identification in there. So then I start looking in those actual statutes. I even went so far to kind of just do a general search and, can I find something about IDing and could someone argue something else? And I even tried looking at some definitions about identification and whatnot in other areas. It brought me to even 943, the Department of Law Enforcement. It wasn't really working. So then I got to medical examiners 406. This is one of the ones that's tested. And the problem was with 145 is it talks about the medical examiner being able to identify an unidentified body. And basically, that is their duty, that if a person dies and no one knows who it is not the office of the local law enforcement. It is not the state highway patrol. It is probably going to be the duty of the medical examiner of that jurisdiction to conclusively identify who the person is. So the Leos might run fingerprints and say, hey, we found, Jack Smith here. And then it goes to the medical examiner. They do the complete forensic write-up. They look at the fingerprints provided by the local Leos or the state Leos, and they go, yep, for certain, this is the person, because that medical examiner has to certify the identity if they are going to provide a death certificate with cause of death. So again, nothing here to kind of help you out with the idea of who is actually, what are your duties as a legally authorized individual to actually identify the body. I then looked at identification of human remains. It's like, oh, Professor Finn, you found it in 497. The problem is not really, okay, because this has to do with the duties of a licensee and identifying who someone is. So what we see is prior to final disposition, the licensee in charge of final disposition of dead human remains shall, prior to final disposition, i.e. cremation, burial, alkaline hydrolysis, composting, transport, affix basically ID. And put ID also on the containers. And the type of identification needs to be durable. Basically, it's a hospital ID band. We put them on the decedents. We even sometimes put them on the handle of a casket right before it goes in a mausoleum or something. Sometimes we do labels. At the end of the day, it just basically something needs to be there. And then if you're going cremation, you are looking at having your urn not just labeled, but something placed inside with the cremated remains to, further identify them. And generally, again, we'll put like a pre-printed business card sized item that has the name of the funeral firm or cremation unit, as well as the name of the decedent and their date of death, actually in with the cremated remains, along with the permanent identification marker or quote unquote dog tag that went through the cremation process that has a physical serial number etched on it. Any licensee responsible for removal of dead human remains to any establishment shall ensure the remains are identified by a tag or other means of identification affixed at the time of removal. So when a person goes to do a transfer from a hospital, from a home, from a field, anywhere, the person transporting that deceased, the funeral agent, must attach an ID at that point. And they are allowed to rely on the identification of whoever is there. So, for instance, if we are going to a hospital, we are essentially obligated to double check the IDs of the decedent while it's on them. So we can look at a hospital ID band and we compare that against to our first call sheet that has the name of the deceased, date of birth, a couple of other personal identifiers maybe, so that we are getting the right individual. And if that tag matches the tag that we have, then we can assume that the remains are conclusively identified. It then goes into cemeteries and direct disposals. And the last thing on here, a licensee charged with responsibility under this section may rely on the representation of a legally authorized person to establish the identity of human remains. And all that means, if a legally authorized person says, yep, that's who this is, we can go ahead and we can work on that. Even if that person is completely clueless, has never met that person in their life, if they are the legally authorized individual and they say that's who it is, we are under no further obligation to establish identity. We can rely on that person and we are done. So there is nothing in here that expressly says that the identification of human remains falls to a legally authorized person if we can previously establish it. And the identity would have been established, say, at the nursing home or at the hospital during the check-in process, during the removal process. Mr. Smith is over in room 242 and bed B. You go to 242 in bed B and there is a dead body there. That is basically identifying the person you're supposed to be there. Not saying it's perfect. I'm just saying that that is what is permitted under Florida law. Exceptions. I thought maybe there might be something hidden in there. Again, nothing under 497.391. Nothing in this chapter may construe to override the written instructions or wish of the deceased as to how her or his body is to be disposed of if such instructions are reasonably available at time of death. And this is a fun one. This one just goes ahead and reinforces the fact that if a person has written directives, they should be enforced over anything else, provided that they are available at the time of death, which is why time and time again I have told individuals, I teach you in my classes, please, for the love of God, share your documents with people so that everyone knows where they're at, so nothing pops up after the fact. I am telling you as a practitioner, it is heartbreaking when someone goes through a funeral process, has to foot the entire bill because they said they prearranged and we couldn't find anything, and sure as sugar later, they find one document hidden in a box in some storage unit that had the name of a funeral home and there was a pre-need and it was completely paid for. And now they're getting hosed because they did not have that information. And the most they're going to get is, whatever that policy may be worth at payout. So that's really sad. So make sure that you share these documents. Make sure that you've given documents to your children, or where things are, so that bad things don't happen. Thought it might be in here under 383. Again, nothing about identification in addition to the common law or statutory rights a legally authorized person may otherwise have. That person may authorize a funeral director or direct disposer licensed under this chapter to lawfully dispose of fetal remains in circumstances when a fetal death certificate is not issued under Chapter 382. And we're not going to get into 382 because that exceeds the scope of this video, and this is going to be long enough. So that has to do with basically if a fetal death certificate is not necessary, they can still dispose of the of the biological matter, the child, however you want to refer to it, depending on your worldview, they are still permitted to go to a funeral director and get things done. And probably the most important thing here is any ambiguity or dispute concerning the right of any legally authorized person to provide authorization under this chapter, or the validity of any documentation purporting to grant that authorization, needs to go to court to have a judge review it. And the judge makes the decision, and that's all there is to it. So again, you're not finding an awful lot here. So then you go diving into, you know, I did a keyword search for dead body, and it pulled up a bunch of different things across everywhere. Again, this wasn't just like for 5 minutes, let's just go ahead and try to peek some things out here. It was, I did some substantial looking here, and I thought maybe they might hide something even in the inspection criteria for funeral establishments. You know, the stuff the state comes in and looks for and says you have to have. And nope, nothing's in there. Sorry. It's just not there. I'm not going to bother displaying it because I already know it's not there. Even went to look at body parts. Maybe there's some way that they, you know, hide things. They pork barrel it somewhere else. And even in 11G, it's not there. Just period. It's not there. So you are really kind of up against the gun here. Looking at 765 and healthcare advanced directives, I did not go in here in depth. Okay, we'll be very clear, I did not go in here in depth. And that is because even if this were relevant, it is applying to a living person. And once you die, we have already seen that if your identity can be confirmed by the institution that you're at, a funeral director can work off that representation. So basically, you're kind of screwed. And then 872 is just offenses concerning dead bodies. Now you know where that is. And there's really nothing more that I can probably give you in regards to where can you find stuff. So let's get to the heart of the matter, which is when there is a dispute, what can a legally authorized person do to enforce a visual identification of the human remains, and what can a funeral home also then request and charge for such services? So the first thing is, apparently under the law, you are not obligated to be given the right to visually ID. Now, again, I am not an attorney, and I am not licensed to practice law, and I am not licensed to give a legal opinion. I'm simply saying, based on the stuff we've looked at, there's nothing that expressly says you have that right under the law. In other states, that is something different. And here's your problem with all of you who used to call me up when I was a funeral director and give me crap about what it's like in your state. You're not in that state. Period. End of story. It does not matter. I understand you need to vent, so I don't take it personal. The fact of the matter is, it just means the state of Florida doesn't give you that right immediately. 2, if you wish to view, can a funeral home charge you for that? And the short answer is yes. The funeral home can charge you for any service they provide. Period. That includes the transfer of the remains. Time and time again, people call a funeral home to get a quote-unquote body out from where it is, and then find out how much things cost, and they're, oh, I got to go somewhere else, and then you're like, well, you still owe me for the pickup. Oh, no, I don't. Blah, 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 blah. So fact of the matter is, from a business standpoint, when you call us up and you say, hey, come get, we are sending an employee on the clock to do that. We are paying for that employee's insurance, so if something happens, that they are covered. We are paying for the insurance on the vehicle. We have the specialized equipment to do all those things. And if we are going to charge a fee, the moment we show up, because you requested us to, we can assess you for that. Now, should we assess you? Well, that depends. Okay, and it has long been my personal view, and what I teach in classes is losing calls is simply the cost of doing business. Because time and time again, I hear analogies like, you know, if you call your plumber and they show up and they do whatever, even if it's just a guesstimate, you know, they can charge you for that. Well, one, I don't mean to demean the art and craft of plumbing, but we are not effing plumbers. Thank you very much. And plumbers sure as hell aren't funeral directors. So within our respective zones of influence, we are separate and above. The correlation of we are businesses certainly does apply. Certainly does apply. So people should not be surprised when funeral directors charge for the service that they have rendered at your request. Now, when can a funeral director not charge for that? Well, that's simple. When the family didn't request it. In which case, they can charge whoever called. We're looking at you, nursing homes and healthcare facilities. If you call us, say, hey, come get because we're full, and they have not authorized the release, which these days most firms require a release to a funeral establishment, or they have an agreement with a local funeral home to pick up and hold, and the funeral home is aware that when they do those things as a courtesy to the hospital, that they run the risk of losing the call and losing the money. So there are some, there are some ways that you can get out of paying a bill, providing at no point in time did you as a legally authorized person ever call someone and say, hey, come pick up and hold. As soon as you do that, you're incurring charges, man. It's a taxi. We just turned on the meter and the meter is running. So don't be surprised, because lots of people are when the funeral home says, yeah, so what about that pickup? If a funeral home can positively establish the ID and there is no disputing it, they may charge whatever fee they wish to charge for that identification. Now, what are some things that funeral homes generally charge you for during an ID? They'll go in, they may pose some features, they may make the remains presentable, and they may charge a nominal fee of like $195 to $295. And you say, well, Professor Finn, that's $300. And in the grand scheme of a funeral, $200 or $300 is not a lot. That's just the truth. There are some places down here that do cremation for, $195, $295, and then with all the add-ons, it's not more than $400, and you pay nearly half that bill with the ID, to which I respond, that is correct, because that is that pricing structure. It does not look like, and I have not seen anything introduced to compel funeral directors to perform a visual identification. Now, what I can tell you is based on some industry leaders. Notably, there are two people that some years ago I was at a Cremation Association of North America conference. We're receiving safe operator training, so I'm a CANA certified safe operator. And the person speaking was a gentleman by the name of Mike Nicodemus, who is something of an authority in the field. And I mean that 100%. He is something of an authority and now runs his own consulting company. And Mr. Nicodemus absolutely will tell you that the best thing you could ever do to limit your liability when it comes to cremation is force people to do a visual identification. And that should be the business model. Build it into your business model and your price structures. And if they choose to waive it, that's on them. And that is Mr. Nicodemus's point of view as of 2008, 2009, because I haven't heard him speak since then. On the other side of that is another gentleman with an equally large national reputation. His name is Bill McQueen. Now, Mr. McQueen is a former owner of the Anderson McQueen family funeral homes in Pinellas County. He has since left funeral service, and he reopened a boutique law firm, Legacy Protection Lawyers, I believe is what it's called. He is, for a number of years, he is a past president of the Cremation Association of North America, and I believe he is still highly sought after as a person to speak on legal matters when it comes to funeral service. So he is also another very qualified individual. He also happens to be my former boss. Well, Mr. McQueen has also said that, based on the laws in Florida, if someone wants to go to court over it, we are also completely justified. So if your state statutes permit you, then no ID is necessary. Now, I'm not saying, again, that Mr. McQueen hasn't changed his mind on that. I'm saying as of 2008 to 2010, that I believe was his point of view. And, Papa Bill can call me up and send me and say, no, dumbass, it's not anymore. That's perfectly fine. But fact of the matter is, you have two industry leaders on the matter. And both of them are on the other side of the fence, essentially, at the same exact time. And both of them are right. Personally, I subscribe to Mr. Nicodemus's point of view, because 100% of the time, I will do whatever I can up front simply to make my life easier later. So that is that Finn's a lazy jerk kicking in ahead of time because I am much more likely to not have an issue ever if someone has positively ID'd. And it is far more concrete in the court of law when someone says, well, how did you establish identity? The person suing me came in and said it is what it is, and this is where they signed, and this is the date they did it. Now what? Versus, let's have a discussion about why the law lets me do things, which may not play well out in front of, say, a jury trial. So again, I'm just thinking differently. So what are your rights? You have the right under the common law, accepted by most all the states, called the right of disposition. A legally authorized person has a non-transferable right of disposition to control all aspects of the funeral arrangement. Now, this is one of those heavy, deep down the rabbit hole topics that we could spend another 40 minutes on, so we're not going to do it. But obviously, part of the right to control is, can I identify? Do I have the right to identify who it is that I am controlling? And there is no apparent God-given right or legal right in the Florida statute to compel a funeral director to give it to you for free. Should you, as a business owner, just suck it up and, give someone an ID when they say so? I'm saying from a liability standpoint, it's probably not a bad idea. You are under no obligation to clean anything up. You're under no obligation to make the situation presentable. You can go ahead and, explain the clinical situation or explain the situation in clinical terms. Explain that on a written instrument, such as a disclaimer. Advise against it because of odors or visual presentation, especially when trauma is involved. You're not here to paint a worst case scenario or a best case scenario. You are there to paint a realistic scenario so the person can make a decision with informed consent. And if you're explaining to them that, there may be odors as a result of, what's in the pouch or whatever it is, and they sign off on it, then they want to bring you in the court, well, you go argue that in court after the fact. But at least they had informed consent.
All my memories gather round her, miner's lady, stranger to blue water, dark and dusty, painted on the sky, misty taste of moonshine, teardrop in my eye, country roads, take me home to the place I belong, West Virginia, Mountain Mama, take me home, country roads.